Imagine a world without courts, without judges, without rights you could name or claim, a world where the only law was the strength of the man standing above you. That world existed, and from it, slowly, painfully, over 1,000 years, grew the legal system that now governs nearly 2 billion people across the English-speaking world. This is that story. Settle in, we're going back to the beginning. Before England was England, before common law existed in any recognizable form, the land was governed by something far older and far simpler: custom. The Anglo-Saxons, who settled the British Isles from around the 5th century onward, had no single legal code. Each region, each kingdom, each village had its own unwritten traditions. Disputes were settled locally, by elders, by community assemblies called moots, or in some cases by the simple and brutal logic of trial by ordeal. Trial by ordeal. It sounds almost mythical now, and in many ways it was. If you were accused of a crime and no witnesses could settle the matter, you might be made to carry a burning iron bar. If your wound healed cleanly within 3 days, God had declared you innocent. If it festered, the opposite was assumed. Or you might be bound and dropped into cold water. If you sank, you were pure. Water, it was believed, rejected the guilty. If you floated, you were condemned. Justice in this world was not a system, it was a ritual. And yet, buried within those local customs, something important was forming. The idea that there should be some standard, some shared expectation of how people ought to treat one another. That idea would take centuries to grow. But it was there. Everything changed in 1066. When William the Conqueror crossed the English Channel and defeated King Harold at the Battle of Hastings, he didn't just win a war. He imposed an entirely new structure of power onto English society, and with it, a new question about law. Who decides and by whose authority? Under the Norman feudal system, the answer was clear: the king. William parceled out the conquered land to his lords in exchange for military service and loyalty. Those lords, in turn, granted portions to lesser knights. And at the very bottom, the vast majority of the population were the serfs, the peasants, the people who worked the land they would never own, subject to the will of those above them. In this world, law was not equal. It was hierarchical by design. A lord held court over his lands. A bishop held court over spiritual matters. The king held court over everything, in theory. But in practice, the kingdom was fragmented. Each manor, each county had its own proceedings, its own customs, its own sense of what was fair and what was punishable. England, in this period, was less a single legal nation than a patchwork of overlapping jurisdictions held together by the force of feudal obligation. And yet, and this is the crucial thing, the Normans brought with them something that would eventually, over generations, begin to unify all of that. They brought the idea of royal justice as a consistent, transferable force, that the king's peace, his authority, his law, could travel with his representatives. That idea would change everything. For the first century after the Norman conquest, royal justice was a sporadic thing. The king had a court, the Curia Regis, the king's council, but it traveled with the monarch himself, and most ordinary people would never see it. That began to change under King Henry II, who reigned from 1154 to 1189. Henry was a remarkable figure, pragmatic, sometimes brutal, but possessed of an extraordinary drive to consolidate royal authority, and he saw the law as one of his most powerful tools for doing so. One of his most consequential reforms was the expansion of the system of itinerant justices, traveling judges sent out from the royal court into the counties of England to hear cases on the king's behalf. These judges would ride a circuit, stopping at county towns, hearing disputes, and applying as best they could the same standards of judgment wherever they went. Now here is where something remarkable begins to happen. These judges came from the same training, the same royal court. When they arrived in Devon or Yorkshire or Kent, they brought with them the decisions and principles that had been applied elsewhere. And when they returned to London, they brought back the local customs they had encountered. Over time, case by case, year by year, a body of shared legal principles began to form, not written down by any single legislator, not proclaimed in any single decree, but accumulated. through decisions, through precedents, through the gradual agreement of judges applying their best reasoning across the whole kingdom. This is the foundation of what we now call common law. Common because it was common to all of England, not the custom of one village or one lord, the shared inheritance of an entire legal tradition. But royal authority left unchecked is a dangerous thing, and by the early 13th century, King John of England had made himself deeply, widely despised. He taxed his barons without consultation, he ignored established customs, he imprisoned people arbitrarily, he demanded loyalty while offering little in return. The barons had had enough. In June of 1215, at a meadow called Runnymede beside the River Thames, they forced King John to set his seal upon a document, a Charter of Liberties. We know it today as Magna Carta, the Great Charter. In its original form, it was not a declaration of universal human rights. Far from it. It was largely a deal between a beleaguered king and his powerful nobles, protecting their privileges and properties. But buried within its clauses was something that would echo across 8 centuries. Clause 39 stated in the language of its time that no free man shall be imprisoned, dispossessed, outlawed, or exiled except by the lawful judgment of his equals or by the law of the land. The law of the land, not the whim of a king, not the mood of a lord, the law. And Clause 40 went even further in its simplicity. To no one will we sell, to no one will we refuse or delay right or justice. In a feudal world where justice was something the powerful administered to the powerless at their discretion, these were extraordinary words. They planted a seed, fragile at first, barely noticed, that due process, that the rule of law, was something even a king was bound by. That seed would take centuries to fully bloom, but it never died. Through the 13th and 14th centuries, the royal court system began to formalize. Distinct courts emerged for distinct purposes. The Court of Common Pleas handled disputes between ordinary subjects, property, debt, contracts. The Court of King's Bench handled matters that touched more directly on the crown, serious crimes, public order. And the Court of Exchequer dealt with financial matters and royal revenue. Each developed its own procedures, its own traditions, its own body of recorded cases, and crucially, the decisions of these courts were increasingly being written down. Not always systematically, not always completely, but recorded, referenced, and eventually cited. A new culture was forming around the law, one that valued not just the outcome of a case, but the reasoning behind it, the principle that had been applied, the logic that had been followed. Because if a judge had reasoned correctly in one case, a later judge facing the same question should follow that same reasoning. Consistency, predictability, the beginnings of what lawyers would later call stare decisis, let the decision stand. It was imperfect, it was slow. The system was riddled with the inequalities of its feudal origins. Access to royal courts was expensive, the law favored those with land and title, and the written record was incomplete. But something recognizable was forming. A system, a tradition, a law common to all. And as England drifted towards sleep on those long medieval nights, in stone manors and mud-walled cottages alike, the foundations of the world's most widespread legal tradition were being quietly, slowly, imperfectly laid. We've only just begun. Every system, no matter how grand its principles, needs people to carry it forward. The common law was no different. As the royal courts grew in importance through the 13th and 14th centuries, a new kind of person emerged in English society, the professional lawyer. Not a priest, not a lord, not a soldier. A man whose power came from something entirely new, the mastery of legal argument. And these men needed somewhere to learn their craft. By the mid-14th century, a cluster of legal societies had formed in London, just beyond the old city walls, between the merchants of the city and the royal courts of Westminster. We know them today as the Inns of Court. The 4 great inns, Gray's Inn, Lincoln's Inn, the Inner Temple, and the Middle Temple, were not universities in any formal sense. There were no degrees to be earned, no examinations to be passed in the modern way. Instead, they were apprenticeships in the oldest tradition. A young man would join an inn, observe proceedings in court, participate in mock debates and exercises called moots, dine with senior lawyers, and absorb, gradually over years, the accumulated wisdom of the legal profession. It was education through immersion, through repetition, through the culture of argument itself. And what these inns produced over generations was something immensely powerful. A class of people who shared a common legal language, who had read the same cases, who reasoned in the same patterns, who, wherever they went, whether as judges, as royal servants, or as advisors to great families, carried that shared understanding with them. The common law needed not just courts to exist, it needed a community to sustain it, and the Inns of Court became that community. But the common law, for all its growing sophistication, had a problem. Actually, it had several. The royal courts, the Court of Common Pleas, the King's Bench, had become, over time, creatures of procedure. To bring a case, you needed the right writ, a formal written order from the Crown that authorized your claim to be heard. There was a writ for trespass, a writ for debt, a writ for the recovery of land. But the list of writs was not unlimited. If your situation did not fit neatly into an existing category, if the wrong you had suffered was new or unusual, or simply didn't map onto any recognized form of action, the court might refuse to hear you at all. And even when a court did hear your case, the remedy it could offer was almost always the same: money, damages, compensation after the fact. What if you didn't need money? What if you needed someone to be stopped, an action prevented, an injustice halted before it caused irreversible harm? The common law courts had no real answer to that. And so quietly, a second legal tradition began to grow alongside the common law. One built not on the cold logic of precedent and procedure, but on something older and more flexible: conscience. When ordinary people found the royal courts closed to them, when justice seemed technically correct but morally wrong, they began to petition the king directly. And because the king could not personally hear every grievance, those petitions were increasingly routed to his chief minister and confessor, the Lord Chancellor. The Lord Chancellor was almost always an ecclesiastic, a bishop or archbishop trained in the moral theology of the church, and his approach to justice was shaped by that training. He did not ask, does this claim fit the correct writ? He asked, is this right? Is this fair? Does conscience demand a remedy? Out of those questions grew an entirely separate court, the Court of Chancery, and an entirely separate body of law, equity. Equity is one of the most important and least understood concepts in the entire history of the common law. It is not, as the name might suggest, simply a synonym for fairness in some vague sense. In legal terms, equity was a specific body of rules and principles developed by the Court of Chancery to provide remedies that the common law could not or would not give. Where the common law said, you may have money for your loss, equity could say, you must hand back what is not rightfully yours, or you must not do this thing you are about to do. These were new kinds of legal power: the injunction, a court order compelling someone to act or to stop acting; the trust, a legal device allowing property to be held by one person for the benefit of another; the specific performance of a contract rather than mere financial compensation for its breach. Equity was, in a real sense, the law filling in its own gaps through the force of moral reasoning. But it created a tension that would persist for centuries, because now England had two parallel legal systems running alongside each other, and sometimes directly against each other. You can imagine how lawyers felt about that. The conflict between common law and equity was not simply a technical dispute between courts. It was a philosophical argument about what law is for. Is it a precise, predictable system of rules that must be followed consistently, even when the result seems harsh? Or is it an instrument of justice that should flex and adapt to ensure right outcomes in individual cases? That tension, in various forms, runs through the entire history of the legal systems we have inherited. And it has never been entirely resolved. By the 16th century, England had entered a new world. The Tudors, Henry VII, his son Henry VIII, and their successors, presided over an England that was changing at every level. The old medieval order was fracturing. The power of the church was being challenged. Trade was expanding. The printing press had arrived. Ideas were moving faster than any horse could carry them. And in this changing world, the law was changing too. Henry VIII's break with the Catholic Church, the English Reformation, was, among many other things, a legal event of enormous consequence. When Henry declared himself the supreme head of the Church of England, he was not just making a theological statement. He was asserting that the authority of law in England flowed from the crown and from the crown alone. Papal courts, church tribunals, the spiritual jurisdiction of Rome, all of this was swept aside or subordinated to royal authority. For the common law, the long-term consequence was significant. The law became increasingly secular, increasingly national, increasingly tied to the authority of Parliament and Crown, rather than to universal church principles. And Parliament itself was growing in importance. Henry needed Parliament to ratify his religious changes, to grant him revenues, to give legal force to his reforms. In using Parliament as his instrument, he inadvertently strengthened it. The habit of legislating through Parliament, of making law through the formal assent of Crown, Lords, and Commons, was being established. This was the slow birth of parliamentary sovereignty. The idea that the highest law in England was not the decree of any one king, nor the accumulated custom of centuries, but the formal expression of the realm's assembled authority. It would take another century of conflict and a revolution before that principle was truly secure. But the Tudors had set the stage. Underneath the great political upheavals of the Tudor age, something quieter and just as important was happening. The law was being written down more thoroughly, more systematically, more permanently than ever before. The printing press, which had arrived in England in the 1470s under William Caxton, transformed the legal world just as it transformed every other world it touched. Before printing, legal knowledge lived in hand-copied manuscripts, expensive, rare, unevenly distributed, and subtly different from copy to copy. A lawyer in Yorkshire might be working from a different version of the same precedent as his counterpart in London. After printing, uniformity became possible. Legal texts, statutes, and collections of reported cases began to circulate in printed form. The great law books of the Tudor and early Stuart period, works by scholars like Anthony Fitzherbert and later the towering figure of Edward Coke, began to codify and explain the common law as a coherent, rational tradition. Sir Edward Coke, in particular, would become one of the most important legal minds England ever produced. His Institutes of the Laws of England were not merely textbooks. They were arguments, sustained, passionate arguments, that the common law was the highest expression of English liberty, that not even a king could override it, that it stretched back through Magna Carta and beyond, to a tradition of English freedom that no act of royal will could extinguish. Coke was not always historically accurate in these claims. He romanticized the past, found precedents that were more invented than discovered. But the argument he was making that the law existed as protection against arbitrary power, that it bound ruler and ruled alike, was one that would ignite revolutions. For now, though, the volumes accumulated on the shelves, the cases multiplied, the tradition deepened, and England slept, uneasily, unknowingly, on the edge of the great constitutional crisis to come. We have traveled 5 centuries in 20 minutes, and still the most turbulent chapter is ahead. Let it carry you gently into the quiet. By the early 17th century, England was sitting on a fault line. On one side stood the crown. King James I, and after him his son Charles I, held to a belief that was ancient and in their minds sacred, the divine right of kings. The idea that a monarch's authority came directly from God, that the king answered to no earthly power, that his judgment was by its very nature beyond the reach of ordinary law. On the other side stood Parliament, and a growing body of lawyers, merchants, landowners, and common people who had absorbed, through decades of legal education, through the printed word, through the arguments of men like Edward Coke, a very different idea. That no one was above the law, not even a king. The collision between these two ideas was not just political. It was not just religious, though religion ran through every thread of it. At its deepest level, it was a constitutional crisis, a crisis about the very nature of law, authority, and who had the right to make and enforce the rules by which a nation lives. Charles I made it worse at every turn. He dissolved Parliament when it displeased him. He imposed taxes without parliamentary consent, a direct violation of principles stretching back to Magna Carta. He imprisoned his opponents without trial. He ruled for 11 years without calling Parliament at all, in a period his critics called the personal rule, and his opponents called something rather less flattering. The tension could not hold. In 1642 it broke. England went to war with itself. The English Civil War, fought between the royalist forces of King Charles and the parliamentary armies led ultimately by Oliver Cromwell, lasted in its various phases from 1642 to 1651. It was not a clean conflict. It was not a simple story of tyranny versus liberty, though it has sometimes been told that way. It was messy, brutal, regionally complex, and theologically tangled in ways that defy easy summary. But its legal consequences were of the first importance. Because at the heart of the war, beneath the battlefield tactics, beneath the religious arguments, beneath the personal animosities, lay a question that the common law had been circling for 4 centuries without ever fully answering. Where does sovereignty reside? In a king who rules by divine mandate? In a parliament which represents, however imperfectly, the interests of the propertied nation? In the law itself, standing above both? The war forced England to answer, and the answer it gave was shocking, even to many of those who gave it. In January of 1649, King Charles I was put on trial. Not by his enemies in the shadows, not by a mob, but by a formal court, a high court of justice, constituted by Parliament, which charged him with tyranny, treason, and being an enemy of the Commonwealth of England. Charles refused to recognize the court's authority. He stood before his judges and told them with quiet dignity that no earthly jurisdiction had the power to try a king. He was not wrong by the standards of the law as it had previously existed. But the court convicted him anyway. And on the 30th of January, 1649, King Charles I of England was beheaded outside the banqueting house in Whitehall. The world had never seen anything quite like it. The Commonwealth, and then the Protectorate under Oliver Cromwell, attempted to govern the nation through Parliament and military authority. It was, in many ways, a legal experiment of unprecedented scale, an attempt to run a kingdom by constitutional means alone, without the ancient focal point of the monarchy. It did not go smoothly. The lesson was uncomfortable but important. Removing a king does not by itself create the rule of law. Constitutions require more than the absence of a monarch. They require institutions, durable, trusted, independent, capable of checking power wherever it accumulates. England had not yet built those institutions, not fully. The army, parliament, and the country looked at the chaos around them and quietly decided they wanted a king back after all. In 1660, Charles II, son of the executed king, returned from exile in Europe and took the English throne. The Restoration. The monarchy was back, but something had changed irrevocably beneath the surface here. The execution of Charles I had demonstrated something that could not be undemonstrated, that a king could be called to account. That sovereignty was not simply divine, it was, in some sense, negotiated, conditional. That idea would not sleep again. The final act of England's constitutional crisis came in 1688, and it came by the standards of the upheavals that had preceded it, with surprisingly little bloodshed. So little, in fact, that history has given it an almost ironic name: the Glorious Revolution. Charles II had died in 1685, and his brother James II had taken the throne. James was Catholic in a nation that had been Protestant for over a century. He appointed Catholics to military and civil offices, suspended the laws that kept them from public life, and showed every sign of intending to reshape England's religious and legal landscape in ways that Parliament found intolerable. The breaking point came when James's Catholic wife produced a male heir, meaning the prospect of a Catholic dynasty stretching into the future. Parliament acted. They invited William of Orange, the Dutch Protestant ruler who had married James's Protestant daughter Mary, to bring an army to England and take the throne. William landed in November of 1688. James's support crumbled. He fled to France, and William and Mary were crowned joint monarchs of England, not by conquest and not by hereditary right alone, by invitation by parliamentary consent. The constitutional significance of that distinction cannot be overstated. Because Parliament, in making William and Mary their monarchs, was asserting something fundamental: that the crown itself was at some level a gift from the nation, that it came with conditions, that those conditions could be, and now explicitly were, written down. In 1689, Parliament passed the Bill of Rights. Not a declaration of abstract philosophy, not a manifesto, a specific practical document listing what the Crown could and could not do, and setting down in law the rights of Parliament and the English people. The Crown could not suspend laws without Parliament's consent. It could not maintain a standing army in peacetime without Parliament's approval. It could not levy taxes except through Parliament. It could not interfere with elections or with freedom of speech within Parliament. And for the individual, for the ordinary subject of the Crown, there were protections too. Excessive bail could not be demanded. Cruel and unusual punishments could not be inflicted. Juries must be properly impaneled. The right to petition the king was affirmed. These were not new ideas. Many of them stretched back to Magna Carta, through centuries of legal argument and parliamentary petition. But here they were, encoded, formal, enforceable, in a way that made the power of the law over the Crown explicit and durable. Parliamentary sovereignty was now the governing principle of the English Constitution. Not the king's will, not divine right. Parliament, the collective voice of the propertied nation, was supreme. The long contest between royal authority and the rule of law had at last produced a winner. Or so it seemed, because the story of the law is never simply a march from darkness to light. Every settlement creates new questions. Every resolution opens new arguments. And beyond England's shores, in the settlements and colonies of the New World, those arguments were already beginning, in new soil, with new voices, carrying the old legal inheritance into futures that no one in Westminster could yet imagine. But that comes later. For now, rest in this moment. A kingdom had reimagined itself. The law had prevailed over the sword, if only for a time. Let the candles dim, let the old halls settle. The story continues when you're ready. The common law did not stay in England. It could not, because England did not stay in England. From the early 17th century onward, English settlers, merchants, Puritans, adventurers, indentured servants, men and women of every station and motive, crossed the Atlantic Ocean and began to build communities on the eastern seaboard of North America. They carried with them everything they owned: tools, seeds, Bibles, fears, ambitions. And they carried something else, something invisible, packed so deeply into their understanding of the world that most of them would not have thought to name it. They carried their legal inheritance, the assumption that disputes should be settled by recognizable process. That property had meaning and protection, that a person accused of wrongdoing deserved some form of hearing. That authority, however rough and improvised in the wilderness of a new continent, was not unlimited. These were not abstract values imported from a philosophy book. They were the lived habits of people shaped by centuries of English legal culture. The common law traveled in the minds and memories of those who had grown up under it. And as the colonies took root, Virginia in 1607, Massachusetts in 1620, and the others that followed across the century, something remarkable began to happen. The settlers did not simply reproduce England on American soil. They adapted, they improvised, they argued. But the framework they argued within, the vocabulary of rights, of due process, of representative governance, was recognizably, unmistakably, the inheritance of the common law. The early colonial courts were nothing like the great Westminster halls of England. They were improvised, understaffed, and often presided over by men with no formal legal training whatsoever. In the earliest settlements, a magistrate might be a clergyman, a militia captain, or simply the most educated man the community could find. And yet, even in that rough informality, the instincts of the common law were present. Cases were heard, evidence was considered, accused parties were given some opportunity to speak. Decisions were recorded, however crudely. And over time, as the colonies grew in population and prosperity, their legal institutions grew more sophisticated. By the mid-17th century, several colonies had produced their own early legal codes. The Massachusetts Body of Liberties, adopted in 1641, was a document of striking ambition for its time. A written list of the rights and protections that colonists could expect, drawn consciously from English legal tradition, but adapted to the conditions of the New World. It prohibited cruel and barbarous punishments. It guaranteed a right to counsel. It protected certain rights of women and children. It affirmed that no person should be condemned without the testimony of two witnesses or their own confession. These were recognizable, if imperfect, echoes of Magna Carta and the common law tradition, filtered through a Puritan moral lens, and pressed into service in a society that was simultaneously trying to survive a wilderness and build a civilization. The colonists knew they were doing something new, but they understood themselves deeply as heirs to something old. As the 18th century progressed, the legal culture of the colonies deepened and professionalized. Trained lawyers began to arrive from England. Colonial-born men began traveling to London, to the Inns of Court, to receive a formal legal education before returning home. And the books of English law, made widely available through printing, circulated through the colonies with increasing reach. One book above all others shaped the legal mind of colonial America. In 1765 and 1769, the English jurist Sir William Blackstone published his Commentaries on the Laws of England, 4 volumes that attempted for the first time to present the entire common law tradition as a coherent, rational, and principled system. Blackstone wrote with extraordinary clarity. He explained the common law not as a tangle of old precedents and procedural technicalities, which is what it looked like from the inside, but as an elegant structure of principles, built up over centuries by the accumulated wisdom of judges applying reason to human affairs. The Commentaries were an immediate sensation. In America, they were particularly influential. At a time when most colonial lawyers had no access to the vast libraries of case reports that a London barrister might consult, Blackstone's systematic summary was transformative. It has been estimated that in the years before the American Revolution, more copies of Blackstone's Commentaries were sold in the American colonies than in England itself. The founding generation, Jefferson, Adams, Hamilton, Madison, all read Blackstone. He shaped their understanding of what law was, what rights meant, and what a legitimate government owed to its people. When they sat down to write the documents that would create a new nation, they were not starting from nothing. They were translating, and in some cases deliberately departing from, a tradition they knew intimately. The argument that led to the American Revolution was, at its core, a legal argument. Not the only argument. There were economic grievances, religious dimensions, personal ambitions, and genuine philosophical differences at play. But the language in which the colonists framed their resistance was the language of the common law. When Parliament imposed the Stamp Act in 1765, a tax on paper goods used throughout the colonies, the colonial response was not simply, "This is expensive." It was, "This is illegal." Illegal, because under the principles of English constitutional law as the colonists understood them, taxation required the consent of the taxed. That principle was not invented by the colonists. It was drawn from Magna Carta, refined through centuries of parliamentary struggle, and enshrined in the 1689 Bill of Rights. No taxation without representation, was not a revolutionary slogan dreamed up in a Boston tavern. It was a statement of common law principle, applied, the colonists argued, to their own situation. The great colonial lawyer James Otis had made the argument even earlier in 1761, challenging the legality of writs of assistance, general search warrants issued by the Crown that allowed officials to search any property without specific cause. Otis argued before the Massachusetts Superior Court that such writs violated the natural rights of Englishmen and the principles of the common law. He lost the case, but a young John Adams watching from the gallery would later write that in that courtroom, the child independence was born. The colonists were not rejecting English law. They were claiming it. They were insisting that the rights it had established over centuries applied to them as English subjects, and that Parliament, in ignoring those rights, had itself become the lawbreaker. That argument could not be contained. In the summer of 1776, the Continental Congress of the American Colonies adopted the Declaration of Independence. It is one of the most famous documents in human history, and it is, at one level, a revolutionary break. A declaration that a people had the right to dissolve the political bonds connecting them to another nation and to constitute themselves anew. But listen carefully to its language. We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness. These are not English legal concepts, precisely. Jefferson drew on Enlightenment philosophy, on Locke, on natural rights theory, as much as on the common law. But the structure of the argument is deeply familiar. The idea that rights pre-exist government, that government derives its just powers from the consent of the governed, that when a government becomes destructive of these ends, a people may alter or abolish it. These ideas had been shaped over centuries by the long conversation between English law and English power, by Magna Carta and the common law courts, by the English Civil War and the Glorious Revolution, by Coke and Blackstone and the lawyers of the Inns of Court. The American founders were not simply rejecting England. In a profound sense, they were arguing that England had rejected its own legal tradition, and that they, the colonists, were its rightful heirs. 11 years later, in Philadelphia in 1787, they would gather again, and this time they would do something no nation had done quite so deliberately before. They would write their Constitution down, every word of it, and they would make it the supreme law of the land. An ocean crossed, a nation made, and still, beneath it all, the long, slow river of the common law flowing on. Let it carry you now into the quiet. In the summer of 1787, 55 men gathered in Philadelphia in the sweltering heat of a Pennsylvania July, closed the windows of the State House to keep their deliberations secret, and set about doing something the world had never quite seen before. They were writing a government into existence. Not describing one that already existed, not petitioning one that had failed them, creating one, from argument, from compromise, from the accumulated legal and political wisdom of men who had read deeply, thought carefully, and lived through the consequences of getting these things wrong. The Articles of Confederation, which had governed the 13 states since independence, had proven inadequate, too weak at the center. No power to tax, no power to regulate trade, no reliable means of enforcing anything. The new nation was, in practical terms, dissolving. What the framers produced over that long summer, after weeks of debate that came close to collapse on several occasions, was the Constitution of the United States. It is a remarkably short document, 4 pages in its original form. It establishes a federal government of 3 branches, legislative, executive, judicial, each with defined powers, each designed to check the others. It divides authority between the national government and the states. It sets out the rules by which laws are made, executives chosen, and judges appointed. What it does not do in its original form is enumerate the rights of individual citizens in any detail. That omission was deliberate and deeply controversial, and it would be corrected almost immediately. Several states had refused to ratify the new Constitution without a promise, a firm, explicit promise, that a Bill of Individual Rights would follow. Virginia, New York, Massachusetts, These were not small voices. Without them, the Constitution could not take effect. And so James Madison, who had been one of the Constitution's principal architects, sat down in the first Congress and drafted what would become the first 10 amendments to the Constitution. Ratified in 1791, they are known collectively as the Bill of Rights. Read them slowly and listen for the echoes. The First Amendment: freedom of speech, of religion, of the press, of assembly, the right to petition the government for a redress of grievances. The Fourth Amendment: protection against unreasonable searches and seizures. No warrants without probable cause, without particular description of the place to be searched and the person or thing to be seized. A direct answer to the general warrants that James Otis had challenged in that Massachusetts courtroom 30 years before. The Fifth Amendment: no person shall be held for a serious crime without the indictment of a grand jury. No person shall be compelled to be a witness against themselves. No person shall be deprived of life, liberty, or property without due process of law. Due process, there it is again. The thread running from Magna Carta's 39th clause through centuries of English legal development, across the Atlantic, into the founding document of a new republic. The Sixth Amendment: the right to a speedy and public trial by an impartial jury, the right to be informed of the charges, the right to confront witnesses, the right to counsel. The Eighth Amendment: no excessive bail, no cruel and unusual punishments. These were not inventions, they were inheritances, refined, recast, made explicit in a way that the English Constitution, which remained unwritten, had never quite managed. The common law had crossed the Atlantic, and in America it had been written down. The Constitution established a Supreme Court, but it said surprisingly little about what that court could actually do. It could hear certain kinds of cases, it stood at the top of the federal judiciary, but its relationship to the other branches of government, its power relative to Congress and the President, was left largely undefined. That definition came from the court itself, and it came through a case that began with a trivial bureaucratic dispute and ended by establishing one of the most consequential principles in the history of democratic governance. The case was Marbury versus Madison. The year was 1803. The facts were, on their surface, unremarkable. William Marbury had been appointed as a justice of the peace by outgoing President John Adams in the final hours of his administration. The incoming Secretary of State, James Madison, acting on President Jefferson's instructions, refused to deliver Marbury's commission. Marbury went to the Supreme Court and asked it to compel Madison to act. The Chief Justice of the United States at the time was John Marshall, a Federalist, a former soldier, a man of formidable intellect and extraordinary strategic patience. Marshall faced a dilemma. If he ordered Madison to deliver the commission, Jefferson would simply ignore the order, and the court's weakness would be exposed for all to see. If he ruled against Marbury, he would be handing a political victory to his opponents. He did neither, and in doing neither, he did something far larger than either outcome would have produced. Marshall ruled that Marbury was entitled to his commission, but that the Supreme Court had no jurisdiction to order its delivery, because the law that purported to give it that jurisdiction was itself unconstitutional. He struck down an act of Congress. In ruling against his own side's immediate interests, Marshall established the principle of judicial review, the power of the courts to declare acts of the legislature void if they conflict with the Constitution. It was a move of breathtaking audacity, and it transformed the Supreme Court from a relatively minor institution into the ultimate arbiter of American constitutional law. Take a moment to appreciate what judicial review actually means, because it is not obvious and it was not universally accepted even at the time. In England, Parliament was supreme. What Parliament enacted became law. No court could strike it down. That was the settlement of 1689. Parliamentary sovereignty as the organizing principle of the Constitution. The American framers had inherited that principle, but they had also created a written constitution, a document explicitly declared to be the supreme law of the land, and they had established a federal judiciary to interpret that document. The question Marshall answered in 1803 was, What happens when an act of Congress conflicts with the Constitution? His answer: the Constitution wins, always, and it is the job of the courts, not the legislature, not the executive, to say so. This was a profound departure from the English model. It created a system in which unelected judges, appointed for life, accountable to no electorate, held the power to override the decisions of democratically chosen legislators. That power has been celebrated and condemned in roughly equal measure across every generation since. Its defenders argue that it is the only reliable guardian of constitutional rights against the tyranny of temporary majorities, that without it, the rights written into the Constitution would be only as durable as the political will to respect them. Its critics argue that it is anti-democratic at its core, that it places the final word on the most contested questions of public life in the hands of a small group of lawyers who answer to no one. Both arguments contain truth, and both arguments are still being made today in law school classrooms, in Senate confirmation hearings, in the decisions of courts around the world that have adopted, adapted, or rejected the American model. The common law had given birth to something it had never quite contained before: a written constitution enforced by courts, supreme over every other source of law. By the early 19th century, the common law tradition, born in the itinerant courts of medieval England, shaped by centuries of judicial reasoning and parliamentary struggle, had taken root across an extraordinary expanse of the globe. Not peacefully in every case. The expansion of the British Empire carried English law into places where it had no indigenous roots, often displacing, distorting, or simply overriding the legal traditions already present. That history is complicated and in many respects deeply troubling, and we will return to its implications. But the legal structures that followed the English flag were, in their essential character, recognizable derivatives of the common law tradition. Canada, outside of Quebec, which retained its French civil law heritage, developed a common law system closely modeled on England's own, with Parliament supreme and courts interpreting an inherited body of precedent. Australia, settled initially as a penal colony from 1788, developed common law institutions that eventually matured into a federal constitutional democracy, adopting a written constitution in 1901 that blended the English parliamentary model with the American federal structure. India, the largest democracy on earth, inherited from British colonial rule a common law framework that it has adapted, debated, and made its own across more than 70 years of independence. And across the Caribbean, in West Africa, in New Zealand and Singapore, and dozens of other former British territories, variants of the common law took root, shaped by local conditions, local cultures, and the determined efforts of local lawyers and judges who made the inherited tradition their own. The common law, by the beginning of the 19th century, was no longer simply English. It was a world legal tradition, imperfect, unequally distributed, marked by the injustices of its imperial origins, but alive, adaptable, and spreading. From a meadow at Runnymede to a courtroom in Philadelphia, from a traveling judge on an English country road to a constitutional court in New Delhi, the river had traveled a long way from its source. And still it flows. Close your eyes, let the distance settle around you. By the middle of the 19th century, the common law was, by almost any honest measure, a magnificent mess. It had grown organically over 7 centuries, layer upon layer of precedent, procedure, writ, and custom, without any single hand ever stepping back to ask whether the whole thing made sense. Because that is the nature of systems that evolve rather than being designed. They accumulate, they contradict themselves. They develop workarounds for their own failures, and then develop workarounds for the workarounds. The result, by the Victorian era, was a legal system of extraordinary complexity and frequently scandalous inefficiency. There were still in England separate courts of common law and courts of equity, each with their own procedures, their own traditions, their own bars. A litigant with a sufficiently complicated dispute might find themselves in multiple courts simultaneously, pursuing overlapping claims under different bodies of law, with no guarantee that the outcomes would be consistent. The delays were notorious. A case in the Court of Chancery, the Equity Court, could last for decades. Families who began litigation over an inheritance might find, by the time a judgment was finally rendered, that the estate had been entirely consumed by the costs of the litigation itself. Charles Dickens, who had worked as a legal clerk as a young man and knew the system intimately, made the Court of Chancery the villain of his novel Bleak House, published in 1852 and 1853. The fictional case of Jarndyce and Jarndyce, a suit over a disputed will that had been grinding through Chancery for so many generations that no one could remember what the original dispute had been about, became one of the most famous indictments of institutional dysfunction in the English language. Something had to change. The Victorian era was, among many other things, an age of reform. The Reform Act of 1832 had begun the long process of reshaping Parliament itself, extending the vote, eliminating rotten boroughs, beginning the slow democratization of the English political system. The same spirit of rational improvement was turned, in time, upon the law. The central figure in the legal reform movement was Jeremy Bentham, a philosopher and jurist who had died in 1832, but whose ideas continued to reshape English institutions for decades after his death. Bentham despised the common law, not its basic purpose. He believed as deeply as anyone in the importance of clear legal rules, but its method, its reliance on unwritten precedent, its resistance to rational examination, its tendency to protect the interests of lawyers and judges at the expense of ordinary people who simply wanted to know their rights and have their disputes resolved efficiently. Bentham argued for codification, the replacement of accumulated precedent with clear, written, systematic legal codes. He wanted a legal system that anyone could read and understand. He called the common law, with characteristic sharpness, dog law, because, he said, it was like training a dog. You wait for it to do something wrong, and then you beat it. You do not tell it in advance what the rules are. Bentham's direct influence on English law was limited. The common law tradition proved too deeply rooted, too beloved by its practitioners, to be swept away by even the most withering philosophical critique. But his ideas drove a generation of reformers to insist on something more modest and more achievable, that the existing system, whatever its philosophical foundations, had to be made to work. And in the 1870s, they succeeded. The Supreme Court of Judicature Acts of 1873 and 1875 were, in terms of their practical impact on the structure of English law, among the most significant pieces of legislation the 19th century produced. They did something that had seemed almost unimaginable for the preceding 2 centuries. They merged the courts of common law and equity into a single, unified court system. The old separate courts, Common Pleas, King's Bench, Exchequer, Chancery, were abolished as independent institutions. In their place arose a Supreme Court of Judicature, divided into divisions, each handling different categories of case, but all operating under unified rules of procedure, and all empowered to apply both common law and equitable principles as the case required. No longer would a litigant need to go to one court for a damages remedy and another for an injunction. A single court could hear the whole dispute and grant whatever remedy justice demanded. The philosophical tension between common law and equity, between rule following and conscience, between precedent and flexibility, was not resolved by this merger. That tension lives on, in various forms, in every common law jurisdiction to this day. But the procedural absurdity of maintaining 2 entirely separate court systems to embody it was finally ended. And the reforms did not stop there. The latter half of the 19th century saw a systematic overhaul of legal procedure, the introduction of clearer rules for pleading, for the conduct of trials, for the management of evidence. The old system of writs, those ancient, rigid forms of action that had constrained the common law courts since the medieval period, was abolished. In their place came a more flexible system of civil procedure in which a claimant simply stated their case in plain terms, and the court determined what law applied. The law was being modernized, slowly, imperfectly, with all the reluctance of a profession deeply attached to its own traditions, but modernized nonetheless. Something else was happening in the Victorian era that would permanently alter the character of the common law tradition. Parliament was legislating at a scale and pace that had no historical precedent. The Industrial Revolution had created problems in labor, in public health, in housing, in commerce, that the common law, built up case by case in response to individual disputes, simply could not address fast enough or comprehensively enough. Society was changing too rapidly for the slow accumulation of judicial precedent to keep up. And so Parliament stepped in, producing wave after wave of legislation. The Factory Acts, regulating working conditions. The Public Health Acts, establishing sanitation standards. The Companies Acts, creating the framework for modern corporate law. The Sale of Goods Act. The Partnership Act. The Bills of Exchange Act. Each of these statutes took an area of law that had previously been governed by a patchwork of common law precedents and replaced it, or at least substantially supplemented it, with written rules enacted by Parliament. This shift had profound implications for the character of the common law system. In a pure common law world, judges make law through their decisions. Precedent accumulates. The law evolves through the steady pressure of cases. Judges are, in a real sense, the primary lawmakers for vast swathes of private and commercial life. As statute came to dominate more and more areas, the role of the judge shifted. Less creator, more interpreter. The question was no longer only, what does the precedent say? It was increasingly, what did Parliament intend? Statutory interpretation, the art and science of reading legislative text to determine its meaning and application, became one of the central skills of the common law lawyer. And it remains so today. In every common law jurisdiction, the relationship between judge-made law and statute law, between common law reasoning and legislative text, is one of the defining tensions of the legal system. Neither has entirely displaced the other. Both are necessary, and the skill of moving between them, of knowing when to reason from precedent and when to yield to parliamentary text, is at the heart of what common law lawyers do. There is one more development of the Victorian era that deserves a quiet moment of attention. By the late 19th century, the common law had become, for the first time, genuinely self-conscious about what it was. Law schools were emerging, not just the Inns of Court with their apprenticeship model, but university faculties of law that studied the common law as an academic discipline. Scholars began to write not just about individual cases or specific areas of doctrine, but about the common law as a system, its principles, its methods, its underlying logic. One figure above all others defined this new academic tradition. Oliver Wendell Holmes, an American jurist, later a justice of the Supreme Court, published his landmark work, The Common Law, in 1881. His opening sentence has been quoted ever since because it captures something essential about the tradition he was describing. The life of the law, Holmes wrote, has not been logic, it has been experience. What he meant was this. The common law is not a geometric system deduced from first principles. It is not a code imposed by a philosopher. It is a living record of how human societies have actually resolved their actual disputes, shaped by history, by practical necessity, by the moral intuitions of successive generations of judges, and only then, after the fact, organized into something that resembles a rational structure. It is, in that sense, profoundly human, messy where human affairs are messy, consistent where human affairs tend toward consistency, capable of change, but resistant to sudden change, because it carries the accumulated weight of everything that came before. Holmes was describing something true not just about American common law, but about the entire tradition stretching back to Henry II's traveling judges riding the circuits of a medieval kingdom. The law is not logic, it is experience given form. And as the 19th century closed, and a new and far more violent century prepared to open, that experience was about to be tested in ways that its Victorian custodians could barely have imagined. The lamp burns low in the library. The books hold their silence. Rest now, the story will still be here. The 20th century arrived with confidence. The Victorian age had bequeathed to its heirs a world of expanding prosperity, advancing science, reforming institutions, and a deep, largely unexamined faith in the idea of progress. The common law tradition, refined over 7 centuries, spread across a quarter of the globe, seemed, to those who administered it, like one of civilization's great achievements. Durable, adaptable, fundamentally sound. And then the century began in earnest. The First World War, fought between 1914 and 1918 across the fields and trenches of Europe, killed somewhere between 17 and 20 million people. It destroyed 4 empires. It shattered the confidence of a generation. And it raised, without quite answering, a question that hung over everything that followed. If civilization could produce this, if the most legally sophisticated, industrially advanced nations on Earth could marshal their entire populations into an engine of mutual destruction on this scale, then what exactly had civilization achieved? The common law tradition had no answer to that question. No legal system did. The peace that followed, fragile, resentful, economically catastrophic, lasted barely 20 years before the world descended again. The Second World War, fought between 1939 and 1945, was worse still. Not just in the scale of its military casualties, but in the deliberate, systematic, industrialized murder of civilians on a scale the world had never witnessed and had barely possessed the vocabulary to describe. 6 million Jews, Roma, disabled people, political prisoners, gay men, Soviet civilians, millions more. Gone. By design. By law in some terrible technical sense, because the Nazi state had passed legislation classifying, excluding, stripping, and ultimately condemning entire categories of human beings. The law had been used as a weapon of extermination. That fact would force the entire legal tradition, common law and civil law alike, to reckon with questions it had never before been compelled to answer directly. In the autumn of 1945, in the bombed-out German city of Nuremberg, an international military tribunal convened to do something that had never been attempted before. To put the leaders of a defeated regime on trial, not to execute them summarily, as some had argued, not to impose a victor's vengeance in the dark, but to try them publicly, with evidence, with defense counsel, with judgment delivered by a court operating under rules of procedure. The Nuremberg trials were imperfect. They were, in some respects, an exercise in retrospective law, charging men with crimes that had not been formally codified as international offenses at the time they were committed. The defendants said so, and they were not entirely wrong. But the men who designed the tribunal, among them the American jurist Robert Jackson, who served as chief prosecutor, made a deliberate and historically significant choice. They chose law over vengeance. They chose process over summary punishment. They insisted that even the worst criminals the world had produced were entitled to hear the evidence against them, to answer it, and to receive a judgment that was reasoned rather than merely felt. Jackson's opening address to the tribunal is one of the great statements of the rule of law ideal. He told the court and the watching world that the privilege of opening the first trial in history for crimes against the peace of the world imposed a grave responsibility. The wrongs which the defendants sought to condemn, he said, were so calculated, so malignant, and so devastating that civilization cannot tolerate their being ignored because it cannot survive their being repeated. Law, in other words, was not a luxury. It was not a refinement available only in peaceful times and set aside in extremity. It was the very thing that separated civilization from barbarism. And its application, even here, even to these men, was not weakness, it was the point. The Nuremberg trials established the modern concept of crimes against humanity, wrongs so grave that they transcended the laws of any individual state and demanded accountability before the community of nations. It was a new idea, and it would change the world. In December of 1948, the newly formed United Nations General Assembly adopted the Universal Declaration of Human Rights. It was the first time in history that an international body had proclaimed in formal terms a set of rights belonging to every human being, not as citizens of any particular state, not as subjects of any particular legal tradition, but as human beings, by virtue of their humanity alone. 30 articles, covering life, liberty, and security, freedom from torture, from slavery, from arbitrary arrest, the right to a fair trial, the right to privacy, freedom of thought, conscience, and religion, freedom of opinion and expression, the right to work, to rest, to an adequate standard of living, to education, The Declaration was not a treaty. It created no binding legal obligations on the states that voted for it. Eleanor Roosevelt, who chaired the drafting committee, called it a common standard of achievement for all peoples and all nations, an aspiration, not an enforcement mechanism. But aspirations in law are never merely decorative. They define the terms of argument. They establish the framework within which future claims are made and future judgments rendered. And in the decades that followed, the Declaration's vision was translated, imperfectly, unevenly, but persistently, into binding legal instruments. The European Convention on Human Rights, adopted in 1950, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights, both of 1966. The common law tradition, which had spent 7 centuries developing the idea that individuals possessed rights the state was bound to respect, now found itself in conversation with a global human rights framework that made the same claim on behalf of all humanity. The two traditions, common law and international human rights law, were not identical. They had different sources, different mechanisms, different geographical reaches, but they shared a fundamental premise: that the individual matters, that power is not unlimited, that there are things a government may not do to a person regardless of what its laws say. That premise had been in the common law from the beginning. Now it was being written into the structure of international order. The Second World War changed not just the international order, it changed what people expected from their governments. In Britain, and across much of the democratic world, the experience of collective sacrifice, of rationing and shared hardship and coordinated national effort produced a political settlement that would have seemed extraordinary to any Victorian lawyer. The state would now guarantee a minimum standard of welfare for every citizen: healthcare, education, unemployment insurance, old age pensions, housing. The welfare state, built in Britain under the post-war Labour government from 1945 onward, was not simply a political project, it was a legal one. Because guaranteeing these things required law, legislation creating the National Health Service, statutes establishing the national insurance system, acts of Parliament defining entitlements, creating agencies, establishing tribunals to resolve disputes between citizens and the state. The common law had traditionally been concerned with the rights of individuals against each other: contract, tort, property, crime. Now, at an accelerating pace, it was being called upon to govern the relationship between the individual and an expanding, intervening, providing state. Administrative law, the body of rules governing how public bodies exercise their powers, grew rapidly in importance. Courts were asked with increasing frequency to review the decisions of government ministers, local councils, welfare agencies, and immigration officials. Were these decisions made within the powers that Parliament had granted? Had the correct procedures been followed? Had the decision-maker taken into account everything relevant and excluded everything irrelevant? Had the individual been given a fair hearing? These were common law questions, rooted in centuries of principle about fairness, about the proper exercise of authority, about the duty to act within the bounds of one's mandate. But they were being asked in an entirely new context, a state that reached into the lives of its citizens in ways no feudal lord or Victorian magistrate could have imagined. The common law was expanding to meet the world that had produced it, and in the expanding it was being remade. By the second half of the 20th century, the language of rights had moved from the margins of legal culture to its very center. In the United States, the Supreme Court under Chief Justice Earl Warren embarked through the 1950s and 1960s on a series of decisions that transformed American constitutional law and, through it, American society. Brown versus Board of Education in 1954 struck down racial segregation in public schools, overturning the separate but equal doctrine that had stood for nearly 60 years. It was a moment in which the court looked at the Constitution's guarantee of equal protection and said, simply and finally, that this is what it means. Miranda versus Arizona in 1966 established that a person in police custody must be informed of their right to remain silent and their right to an attorney before any questioning begins. The Miranda warning, now so familiar from decades of American television and film, was born in that courtroom, out of the Sixth Amendment's right to counsel and the Fifth Amendment's protection against self-incrimination. Rights that traced their lineage, through the centuries, back to principles Edward Coke had argued for in the courts of Stuart England. In Britain, the Human Rights Act of 1998 incorporated the European Convention on Human Rights directly into domestic law, giving British courts for the first time the power to hold government action to account against a written list of fundamental rights. It was a significant constitutional moment, because while Britain had always had the common law protections built up over centuries, it had never had a single accessible document that any citizen could point to and say, "Here, these are my rights. This is what the state may not do." The Act did not make Parliament's laws invalid if they conflicted with Convention rights. Parliamentary sovereignty, the settlement of 1689, remained intact. But it required courts to interpret legislation compatibly with those rights wherever possible, and to issue a declaration of incompatibility when it was not. It was a carefully balanced compromise between the old English tradition of parliamentary supremacy and the new international tradition of judicially enforced rights. And it was unmistakably a descendant of everything that had come before. Of Magna Carta's insistence that even a king was bound by the law of the land, of the Bill of Rights' enumeration of what the crown could not do, of the common law's centuries-long project of building case by case a set of expectations about the proper limits of power. The line from 1215 to 1998 was not straight. It was broken in places, diverted in others, lost entirely for stretches before being found again. But it was real. It had always been real, 780 years from Runnymede to the Human Rights Act, and the argument still being made, still being refined. Let the thought settle gently. In the final decades of the 20th century, the world began to move at a speed the law was not designed for. Globalization, the accelerating integration of national economies into a single, interlocking system of trade, finance, and production, did not happen by accident. It was built on law, on treaties and trade agreements, on commercial arbitration clauses and intellectual property frameworks, on the international conventions that govern shipping, aviation, finance, and the movement of goods across borders. And the common law, it turned out, was exceptionally well suited to the demands of a global commercial order. Because the common law tradition had always prized something that international commerce requires, there is another challenge pressing on the common law tradition with increasing urgency, one that is, in some ways, the most fundamental of all. Climate change. The scientific consensus is unambiguous. The planet is warming, driven by human activity, and the consequences, rising seas, extreme weather, displacement, ecological collapse, are already being felt and will intensify across the coming decades. This is not primarily a legal problem, it is a political and technological one. But the failure of political systems to respond at the scale and speed that science demands has driven a growing number of individuals, communities, and advocacy organizations to turn to the courts. Climate litigation, the use of legal action to compel governments and corporations to address their contributions to climate change or to compensate those harmed by it, has expanded dramatically in the first quarter of the 21st century. The legal arguments being deployed are characteristically drawn from the deepest wells of the common law tradition. Tort law, specifically the ancient doctrine of public nuisance, the idea that an activity causing widespread harm to the public is legally actionable, has been invoked against fossil fuel companies. If a corporation knowingly contributed to a harm of this scale, knowing for decades what its products were doing to the atmosphere, does the law of nuisance reach it? Constitutional arguments have been raised. Do governments have a legal duty, grounded in constitutional rights to life, to a healthy environment, to the well-being of future generations, to adopt policies that limit climate harm? Courts in the Netherlands, in Germany, in Colombia, in Pakistan have said yes. Courts in common law jurisdictions have begun to reach similar conclusions. And the law of trusts, That ancient equitable device developed by the chancellors of medieval England to ensure that property was managed for the benefit of its intended beneficiaries has been reimagined by some legal thinkers as a framework for the relationship between present generations and the future. If the atmosphere is a commons held in trust for all humanity, including those not yet born, what duties does that impose on those who govern its use today? These arguments are contested. Many of them have failed in court. Many are still working their way through the system, untested and unresolved. But the fact that they are being made at all, the fact that the conceptual tools of the common law tradition are being stretched and reshaped to address a planetary emergency, is itself remarkable. A tradition designed to resolve disputes between neighbors over fields and fences is being asked to adjudicate the future of the earth. Across the common law world, the constitutional settlements that have governed political life for generations are showing signs of strain. In the United Kingdom, the years surrounding the Brexit referendum, the 2016 vote to leave the European Union, and the turbulent legal and political years that followed, produced a series of constitutional moments of unusual intensity. The Supreme Court of the United Kingdom, itself a relatively new institution, established only in 2009, was asked to rule on questions that went to the heart of the Constitution. Could the government use the ancient prerogative power of the Crown to trigger the withdrawal process, bypassing Parliament? No, the court ruled. Parliament must be involved. Could the Prime Minister prorogue, suspend Parliament for 5 weeks during the most critical period of the Brexit process? No, the court ruled again that prorogation was unlawful, an attempt to frustrate Parliament's constitutional function. These were not technical legal disputes. They were contests over the most fundamental question of constitutional law, where power resides and what its limits are. The same question that had driven the English Civil War. The same question that Magna Carta had first imperfectly begun to answer. In the United States, the Supreme Court has faced its own moments of institutional stress. Its decision to overturn Roe v. Wade in 2022, reversing nearly 50 years of constitutional precedent on abortion rights, produced a debate about the nature of the court's authority, the legitimacy of its reasoning, and the proper relationship between judicial decision-making and democratic governance that remains raw and unresolved. The doctrine of stare decisis, the principle that courts should stand by their previous decisions, the very foundation of the common law's claim to consistency and predictability, was invoked, challenged, and ultimately overridden. The court said, in effect, that a previous court had reasoned wrongly, and that the error should be corrected however old and however embedded it had become. Whether that was right or wrong is a question on which reasonable people disagree profoundly. But the episode revealed something important about the common law tradition's self-understanding. It has never claimed to be infallible. It has always contained within itself the seeds of its own revision. Precedent is authoritative, but it is not eternal. The tradition moves, it argues with itself, it changes its mind. Sometimes that is its greatest strength. Sometimes it is the source of its deepest anxieties. Beneath the specific legal debates of the present moment, AI, climate, constitutional interpretation, there runs a deeper anxiety about the rule of law itself. The rule of law, the idea that everyone, including those who wield power, is subject to the same legal rules applied consistently by independent courts, is not a fixed achievement. It is a practice, a habit, a set of institutional arrangements that must be actively maintained because they can be eroded, gradually or rapidly, when those in power find them inconvenient. In the years since the 2008 financial crisis across a wide range of democracies, including common law democracies, there has been a measurable decline in institutional trust, in legislatures, in courts, in the professions, including the legal profession. People who feel that the law has not served them, that it has been one set of rules for the powerful and another for everyone else, have become, in growing numbers, skeptical of the entire enterprise. That skepticism has been exploited by political movements willing to delegitimize courts when they produce inconvenient decisions, to attack judges as enemies of the people, to argue that democratic majorities should not be constrained by the rulings of unelected lawyers. These arguments are not entirely without foundation. Courts can be wrong. They have been wrong, consequentially, and in ways that caused great harm. The insulation of judges from democratic accountability is a genuine tension within the constitutional order of every common law jurisdiction. But the argument that inconvenient court decisions should be ignored, that judges who rule against the government are acting politically rather than legally, that the rule of law is a constraint only for those who have already won, that argument, taken to its conclusion, leads somewhere the common law tradition has been to before. It leads to the world before Magna Carta, to the world where the only law was the strength of the man standing above you. The tradition did not develop over 8 centuries by accident. It developed because every generation that inherited it, imperfect, unjust, partial as it was, found on reflection that it was better than the alternative. That judgment has to be made again in every generation. It is being made now. The common law tradition has survived because in every era there were people willing to work within it and to argue with it. Judges who applied principles carefully and recorded their reasoning honestly. Lawyers who pressed novel arguments in the service of neglected clients. Reformers who identified the tradition's failures and pushed decade after decade to correct them. Ordinary people who showed up to courts and tribunals and insisted on being heard, sometimes winning, sometimes losing, but insisting. The tradition is not self-sustaining. It does not maintain itself. It is maintained by the people who engage with it, who argue within its framework, who hold its institutions to their own stated standards. This is what distinguishes the rule of law from the mere existence of rules. Rules can be imposed. The rule of law has to be believed in, not naively, not without criticism, but with enough commitment to keep showing up, keep arguing, keep insisting that the institutions responsible for justice are held to their obligations. That is an ask. It is not a small one. It requires believing, even when the law fails you, and it will fail people, it has always failed people, that the framework within which the argument about justice is conducted matters. That process is not just procedure, that the right to be heard, to have your case reasoned through rather than dismissed, to receive a judgment that explains itself, that these things have value independent of any particular outcome. 800 years ago, in a meadow by a river, a group of barons forced a king to acknowledge, however reluctantly, however insincerely in that particular moment, that his power was not unlimited, that there was a law above him. The argument that began at Runnymede in 1215 has never ended. It has grown more sophisticated, more global, more complex, and in many respects more just, though never just enough. It is still going. And you, listening now, in whatever corner of the world the common law has reached, are part of it. Rest in that, in the long, long story of which you are a part. The night is deep, and the argument continues patiently in the morning. We have traveled a great distance tonight. From the Anglo-Saxon moots and their trials by fire and water, through the Norman courts and Henry II's traveling judges, through the birth of equity and the turbulence of the English Civil War. Across the Atlantic with the Puritan settlers and their transplanted legal instincts, through the Philadelphia summer of 1787 and the courtroom of John Marshall, through Victoria's reforming century and Holmes's quiet revolution in legal thought, through the wreckage of 2 world wars and the cautious hope of Nuremberg and the Universal Declaration, into the digital present, the climate courtrooms, the constitutional arguments that show no sign of resolution. It is a long story, and it is easy in surveying it at this scale to lose sight of what it was actually made of. It was not made of principles. Principles do not argue themselves. It was not made of institutions. Institutions do not build themselves. It was made of people. Specific, flawed, often frightened, sometimes courageous people who showed up day after day to the slow work of reasoning about what justice requires. The medieval judge riding a cold circuit through the English counties in November, hearing disputes between farmers over boundaries and debts, recording his reasoning in imperfect Latin because someone had to and because the recording mattered. The Chancery clerks who managed the paperwork of an equity jurisdiction that served hundreds of thousands of petitioners over 5 centuries, most of whose names no history book has ever recorded. The colonial lawyer in a Boston courtroom in 1761, making an argument he knew would fail, before an audience that included a young man who would later say that in that room, independence was born. The women who, in the 19th and 20th centuries, fought to enter a legal profession that had been designed without them and against them, who argued using the very tools of common law reasoning that the exclusions built into the system were incompatible with its own stated principles. The legal aid lawyers of the 20th century, underpaid, overworked, operating in systems that gave them too little time and too few resources, who nonetheless showed up for clients the market would never have served. The tradition is the sum of all of them, of all those hours, all that effort, all that careful, persistent, unglamorous work. It deserves to be understood that way. The common law has a peculiar relationship with time. Most human institutions, governments, companies, churches, universities, have histories. They remember their past in various ways, and it informs their present. But the common law does not merely remember its past. It is bound by it. The doctrine of precedent, stare decisis, let the decision stand, means that a judgment handed down by a court in 1851 is not merely a historical curiosity. It is, in the right circumstances, binding on a court sitting today. The reasoning of a Victorian judge working through a dispute about railway liability or contractual frustration remains part of the active legal fabric of the present. This is extraordinary when you stop to think about it. In no other field of human endeavor do we routinely ask, in a professional, binding, formal sense, what a practitioner 2 centuries ago thought about a problem, and then follow that thinking as a matter of obligation rather than mere interest. The common lawyer lives in a kind of extended present that stretches back through centuries. When a barrister argues a negligence case in a London court today, they are, in a real sense, in conversation with a judgment from 1932, Donahue versus Stevenson, the case of the decomposed snail in the opaque ginger beer bottle, which established the modern law of negligence and the principle that we owe a duty of care to our neighbors in law, meaning anyone we can reasonably foresee being affected by our actions. That case is nearly a century old. Its facts, a woman, a ginger beer bottle, a dead snail, a Scottish cafe, could hardly be more modest, and yet the principle it established has been applied, extended, limited, distinguished, and debated in courts around the world ever since. That is what precedent means, not the mechanical repetition of old decisions, but a living conversation across time, in which the reasoning of the past is taken seriously, tested against new facts, and either applied or carefully, explicitly departed from. The common law is, in this sense, a form of institutional memory, a way of ensuring that the hard-won wisdom of one generation about what kinds of arrangements produce conflict, what kinds of promises should be enforceable, what kinds of harm deserve remedy, is not lost when that generation passes. It is imperfect memory, selective, sometimes distorted, carrying the biases of its era, but it is memory nonetheless. And the alternative, starting fresh with every generation, reasoning about justice from first principles without the benefit of everything that has been tried and argued and decided before, would be a kind of institutional amnesia that no legal system has ever been able to survive. In 1928, a woman named May Donahue traveled by tram from Glasgow to a cafe in the town of Paisley with a friend. Her friend bought her a bottle of ginger beer. The bottle was made of dark, opaque glass, the kind you cannot see through. May drank some of it, and then her friend poured the rest into the glass. And out, with the remaining ginger beer, came the decomposed remains of a snail. May Donahue became ill. She suffered, she later said, from gastroenteritis and severe shock, and she decided to take legal action. The difficulty was this. Her friend had bought the ginger beer. The contract, the legal agreement, was between her friend and the cafe owner. May herself had no contract with anyone, and under the law as it then stood, without a contract, she had no obvious cause of action, no recognized legal right that had been violated. Her lawyers took the case all the way to the House of Lords. then the highest court in the United Kingdom. And in 1932, in a judgment written by Lord Atkin, the court held that May Dontague was entitled to sue the manufacturer of the ginger beer. Not because of a contract, but because the manufacturer owed her a duty of care. Lord Atkin reached for a principle older than any legal precedent. He asked, "Who, in law, is my neighbor?" And he answered, borrowing from the parable of the Good Samaritan, that your neighbor, in law, is anyone whom you ought reasonably to have in your mind as likely to be affected by your acts or omissions. The manufacturer of a sealed bottle of ginger beer, Lord Atkin reasoned, ought reasonably to have in mind the ultimate consumer of that bottle. They owe that person a duty not to be careless in the preparation of their product. A snail, a bottle, a tram ride to Paisley, and from those modest, accidental, entirely ordinary facts, the modern law of negligence. The principle of duty of care, applied today in every common law jurisdiction in the world, in cases involving medical malpractice, road accidents, product liability, professional negligence, and 100 other categories of harm. The law does not always announce its great moments in advance. Sometimes it arrives in a cafe, in the dark residue of a ginger beer bottle. On a rainy afternoon in Scotland. In the winter of 1891, a company called the Carbolic Smoke Ball Company placed an advertisement in the Pall Mall Gazette. And in their advertisement, they made a very specific promise. They would pay £100, a very substantial sum in 1891, to any person who used the smoke ball as directed 3 times daily for 2 weeks and still contracted influenza. As proof of their sincerity, they announced they had deposited £1,000 with the Alliance Bank in Regent Street. She contracted influenza. She wrote to the Carbolic Smoke Ball Company and asked for her £100. They declined to pay. The company argued that their advertisement was merely a puff, a bit of commercial enthusiasm, not a legally binding offer. No reasonable person, they suggested, could have understood it as a genuine promise. The Court of Appeal disagreed entirely and with some relish. The advertisement, the court held, was a valid offer, made to the whole world, capable of being accepted by anyone who performed the stipulated conditions. Mrs. Carlyle had accepted it by buying the smoke ball and using it as directed. The deposit of £1,000 with a named bank was, the court observed, evidence of unusual sincerity for a commercial advertisement. It showed that the company meant what it said. Carlyle versus the Carbolic Smoke Ball Company is still taught in every common law contract course in the world. Not because carbolic smoke balls matter, but because the case crystallizes with wonderful clarity the principles of offer and acceptance, the foundations of the law of contract, the mechanism by which a promise made to a stranger under the right conditions becomes a legal obligation. The law, as Mrs. Carlyle discovered, sometimes has a dry and patient sense of humor. Not all legal stories end in justice. Some end in something considerably stranger. In the 18th century, 2 highwaymen, men who made their living by robbing travelers on the roads of England at gunpoint, entered into a business arrangement. One of them, it turned out, was not accounting. Honestly, he was keeping more than his share. His partners sued him. In the court of Chancery, the court of conscience, remember, the court that asked not what the law permitted, but what fairness required, the case came before a judge named Lord Mansfield. Lord Mansfield heard the claim, and then he declined, with considerable firmness, to enforce it. His reasoning was simple. The court would not assist a party who came before it seeking the fruits of an illegal enterprise. It did not matter that the arrangement had been made honestly, or that the plaintiff had genuinely been cheated. The foundation of the claim was a criminal conspiracy. A court of equity would not lend its authority to resolving disputes arising from it. The principle that emerged, known today as the doctrine of illegality, or in its Latin formulation ex turpi causa, holds that no court will enforce a contract or a claim that is rooted in the plaintiff's own illegal conduct. It is a principle still applied today. A drug dealer cannot sue for the price of drugs supplied. A fraudster cannot claim their share of the fraudulent proceeds. The court, Lord Mansfield was saying, is not a service available to everyone without condition. It is an instrument of justice, and justice has no interest in ensuring that criminals honor their agreements with one another. The highwayman went unsatisfied. The principle they inadvertently helped to establish has been part of the common law ever since. There is a texture to the common law that is difficult to describe from the outside, and that those who have spent time inside it tend to carry with them for the rest of their lives. It is partly the texture of language. Common law reasoning has its own vocabulary, terms of art that carry centuries of meaning compressed into single words. Tortfeasor, promissory estoppel, nemo judex in causa sua, no one should be a judge in their own cause. Audi alteram partem, hear the other side. These are not decorative phrases. Each one is the residue of arguments made, cases decided, principles established, and then refined over decades and centuries of application. When a lawyer reaches for one of these terms, they are reaching for a tool shaped by all those hands. It is partly the texture of argument. Common law advocacy has a particular quality, a combination of logical rigor and narrative skill, of close textual analysis and appeal to principle, of engagement with precedent and willingness to argue that the precedent should be departed from or distinguished. It is a form of reasoning that is both highly constrained. You must work within the framework of what has been decided before, and remarkably creative, because within those constraints, the space for argument is enormous. And it is partly the texture of the institution itself, the court as a physical space, the formality that slows things down, that requires patience and procedure, that makes the resolution of even a modest dispute feel to those participating in it like something that matters, because it does matter. It matters to the people involved. And the formality, however irritating it sometimes is a way of acknowledging that. The common law is ultimately a culture, not just a set of rules, a way of thinking about problems, a set of habits of mind, a shared framework for the kind of argument that civilized life requires. It is passed on not just through textbooks and case reports, but through practice, through the experience of sitting in a courtroom and watching how a skilled advocate addresses a judge, through the experience of constructing an argument and having it tested, challenged, and sometimes demolished by someone who has been doing this longer than you have. It is learned the way all deep knowledge is learned, by doing it over time in the company of those who know it better than you do. The law, at its best, makes a particular sound. Not a loud sound, not a dramatic one. The dramatic moments, the verdicts, the constitutional rulings, the landmark judgments that make the front pages are not the sound the law makes when it is working well. Those are the occasions when the law is being tested to its limits, when something has gone wrong or reached a crisis. They are important, but they are not representative. The sound the law makes, when it is working, is quieter than that. It is the sound of someone being heard, of a complaint being taken seriously, of evidence being examined rather than dismissed, of a question being reasoned through rather than answered by whoever happens to have the most power in the room. It is the sound of a magistrate on an unremarkable Tuesday morning in a small town, working through a list of cases with patience and care, knowing that each name on that list is a person whose situation matters, whose rights are engaged, whose life may be affected by what happens in this room. It is the sound of a judge reading a skeleton argument late in the evening before a hearing, trying to understand a case well enough to ask the right questions the next morning. not because anyone will know whether the preparation was thorough, but because the parties deserve a judge who has tried to understand their dispute. It is the sound of a law student at 2 a.m. working through a problem question, learning for the first time to hold 2 competing principles in mind simultaneously and to reason carefully about which one should prevail. These are not glamorous sounds. They are not the sounds that make it into documentaries or courtroom dramas, but they are the sounds on which everything else depends. The daily, unheroic, essential work of people who take the law seriously enough to do it properly. When the law is making that sound, when those sounds are being heard consistently in enough places, something important is happening. Something that the world before Magna Carta did not have and that the world after Magna Carta has been building, imperfectly and incompletely, ever since. A place where reason governs, where argument counts, where the outcome is not simply the expression of whoever has the most force. It is enough. On most days, it is more than enough. Listen for it in the quiet. That sound. From here, in the quiet, it is possible to see the whole of it. The full length of the road, 8 centuries of argument about how power should be constrained, about what a person is owed simply by virtue of being a person, about the difference between authority that serves those beneath it and authority that merely serves itself. The road is not straight. It doubles back. It loses itself in marshland. It climbs hills that turn out to lead nowhere useful, and descends into valleys where the light barely reaches. There are stretches where it seems to disappear entirely, where the law became an instrument of the very oppression it was supposed to prevent, where the powerful bought it and the weak went without it, and the distance between the promise and the reality was a chasm that swallowed whole generations. But the road continues, it always has. And in the long view, the view only available from a great distance, at the end of a long night, the direction is visible, the direction is real. From a world where justice was what the strongest man in the room decided it was, to a world imperfect, contested, unfinished, in which the idea that everyone is entitled to be heard, that power must answer for itself, that the individual has claims the state is bound to respect, is not merely an aspiration. It is a practice, embedded in institutions, tested daily in courts and tribunals and lawyers' offices and magistrates' rooms in every English-speaking country on earth. The practice is fragile, it needs tending. Every generation that inherits it inherits also the responsibility to tend it. But it exists, and that, after everything, is not a small thing. Most of the people who built this tradition are unknown. The clerks who copied out the early plea rolls by candlelight in the 13th century, recording the cases that would become the first precedents, in a hand now faded to near illegibility on vellum, that has somehow survived 800 years. The local magistrates of the 17th and 18th centuries, farmers and minor gentry, doing their best with Blackstone's Commentaries and common sense, settling disputes in market towns that no one now remembers. The advocates of the colonial period, who argued cases in courts that met in taverns, who built legal institutions out of almost nothing, in places where the law had no history, and the future was entirely unclear. The reformers of the 19th century who spent their careers, whole careers, decades of patient, unglamorous effort, pressing for changes to legal aid, to court procedure, to the rights of women and workers and tenants, changes so incremental that no single one of them seemed worth a biography, but whose accumulation transformed what the law could offer to ordinary people. The names we know, Magna Carta's barons, Coke, Blackstone, Marshall, Holmes, are the tips of an iceberg whose body is composed of people who did necessary work in obscurity and were never celebrated for it. That is how traditions are actually maintained, not by the great figures whose names appear in the textbooks, by the far larger number who showed up every day, did the work carefully, and passed it on. There is something quietly consoling in that thought. The tradition does not depend on exceptional people. It depends on ordinary people doing their part with sufficient care and sufficient commitment, on enough of them, in enough places, over enough time. You do not have to be extraordinary to contribute to something extraordinary. You only have to show up, and take it seriously. There is an image that keeps returning in thinking about the common law. A river, not a dramatic river, not a torrent, something slower than that, deeper. A river that has been moving for so long that it has shaped the entire landscape around it, that the valleys and plains and cities it passes through owe their form to a degree most of their inhabitants never notice, to the fact that this river has been here, moving in this direction, for longer than anyone can remember. The common law is like that river. It began as something small, a few courts, a few judges, a thin trickle of recorded decisions, and it moved, slowly over centuries, gathering volume. Other streams joined it: equity, statute, international law, human rights, each one changing its character slightly, adding to its depth. It carved its path through the landscape of human affairs, through monarchy and revolution, through empire and independence, through war and reconstruction, and the quiet, persistent work of peacetime institutions going about their daily business. And it carries things with it. Old decisions, ancient principles, the reasoning of judges who have been dead for 5 centuries, still present in the current, still part of what shapes where the river goes. It is not a pure river. No river is. It carries silt and debris alongside the clear water. The history of injustice it has been party to does not wash clean simply because so much time has passed. But it moves. It always moves, and the movement over time has been toward depth, toward breadth, toward reaching more of the land through which it passes. That is the nature of a living legal tradition. Not fixed, not finished, always in motion, always carrying something forward. If you are still with me now, still following this long road through the dark, then you have traveled a considerable distance tonight. From a world that had no courts, no rights, no law worth the name, only the authority of whoever happened to be standing above you with a weapon, to a world that has, however imperfectly, built something different. A world in which the argument about justice is at least being made, in which the institutions responsible for that argument, however badly they sometimes fail, at least exist and can be held to account. That is a difference worth understanding. And perhaps in understanding it, in seeing how long and how difficult and how many-handed the work of building it has been, there is something that resembles gratitude. Not the comfortable gratitude of those who have never needed the law's protection, but the more sober gratitude of those who understand what the alternative looks like, who have seen in the historical record what happens when the rule of law fails, when courts are captured, when the powerful are exempted from accountability, when the weak have no forum. The common law tradition is not the only answer to those dangers. Other legal traditions have developed their own frameworks, their own mechanisms, their own responses to the eternal problem of power. But this tradition, this long, strange, accidental, English-born, world-traveling tradition, is the one whose story we have followed tonight, and it has earned, across its 8 centuries of effort and failure and reform and persistence, something more than mere familiarity. It has earned attention, careful, critical, demanding attention, which is the only kind worth giving. The law will still be there in the morning. The cases will still be working their way through the courts. The arguments will still be being made. Somewhere tonight, in a different time zone, a judge is writing a decision that will become a precedent. Somewhere, a law student is reading a case for the first time and feeling the particular sensation, difficult to describe, of a principle becoming clear. Somewhere, a person who has been wronged is sitting across a desk from a lawyer who is explaining what the law can and cannot do for them. The work continues. It does not need you to be awake for it to continue. It does not need anyone to be awake. It runs on in the way that old, deep, well-established things run on, through the quiet, through the dark, without requiring witness or applause. The river moves whether anyone is watching it or not. The precedents hold. The principles persist. The institutions open their doors again tomorrow morning, as they have opened them every morning for centuries, and the argument resumes. You can rest now. The law is keeping its watch. It has always kept its watch. From a meadow by the Thames in the summer of 1215 to wherever you are listening to these words tonight, in whatever corner of the world the long, slow current of the common law has reached. It has traveled a long way to reach you. Rest in that. The morning comes, and with it, as it always has, the law. Above almost everything else, predictability. The doctrine of precedent meant that contracting parties in a common law jurisdiction could have reasonable confidence about how their agreements would be interpreted, what remedies would be available if they were broken, and how courts would reason through disputes they had not anticipated. This predictability made common law jurisdictions, particularly England and Wales, and to a significant degree the United States, the chosen legal homes of international commercial agreements. To this day, an extraordinary proportion of the world's significant commercial contracts, transactions between parties who may have no connection to England whatsoever, specify English law as the governing law and English courts or London arbitration as the chosen forum for dispute resolution. A medieval king's traveling judges, riding the circuits of a damp island on the northwestern edge of Europe, could not have imagined this. And yet the tradition they built, the accumulated reasoning of centuries of English common law courts, became the preferred legal framework for global commerce. The common law had become, in a real sense, the world's commercial law. One of the most consequential legal inventions in the entire history of the common law is one that most people rarely think about as a legal invention at all. The corporation, the idea that a group of people could pool their resources, create an entity that was legally distinct from any of them individually, and conduct business under that entity's name with limited liability, meaning that the investors risked only what they had put in and not their entire personal fortune, was not obvious. It had to be invented. And it was invented gradually through a combination of statutory development and common law reasoning across the 17th, 18th, and 19th centuries. The landmark moment in England was the Joint Stock Companies Act of 1856, which made limited liability incorporation straightforwardly available to any group of people who followed the prescribed procedure. Before that, incorporation had required a special act of Parliament or a royal charter, an expensive, cumbersome process available only to major enterprises like the East India Company or the great trading guilds. After 1856, the corporation became democratized. Any merchant, any manufacturer, any entrepreneur could incorporate, and the effects were transformative. Capital could be raised from many investors simultaneously, each bearing only limited risk. Large enterprises, railways, mines, factories, banks, could be built and managed at a scale that no individual fortune could sustain. The corporate form became the organizing unit of the industrial economy. And it has remained the organizing unit of the global economy ever since. Today, the world's largest corporations command resources that dwarf the budgets of many nation-states. They operate across dozens of jurisdictions simultaneously. They shape the daily lives of billions of people, as employers, as suppliers of goods and services, as platforms mediating communication and commerce. And the law that governs them, that determines how they may be structured, how their directors must behave, what duties they owe to shareholders and to others, is, at its foundation, common law, refined and supplemented by statute, adapted to local conditions in every jurisdiction, but rooted in centuries of legal reasoning about authority, accountability, and the proper exercise of power. The same tradition that had asked, in the 13th century, what a king could do to his subjects was now asking what a corporation could do to its customers, its workers, and its communities. The questions were different. The instinct behind them was the same. In 1989, a British scientist named Tim Berners-Lee, working at a research laboratory in Switzerland, wrote a memo proposing a system for sharing information across a global network of computers. He called it, at first, simply an information management system. His supervisor reading the memo wrote 2 words across the top of it: vague but exciting. Within a few years, what Berners-Lee had proposed had become the World Wide Web, and within a decade of that, it had begun to reshape every dimension of human life: commerce, communication, politics, privacy, identity, at a speed that no previous technology had approached. The law was not ready. This is not a criticism. The law is never ready for genuinely new things. It works by analogy, by asking how existing principles apply to new situations, by reasoning from what has been decided before to what should be decided now. When the new situation is sufficiently unlike anything that has come before, that process takes time. The internet presented the common law with a cascade of genuinely new problems. Who is responsible when someone is defamed on a platform they did not create, by a person they cannot identify, to an audience distributed across 100 countries? Whose law applies? Which court has jurisdiction? Who owns information? Does a person have rights over data that describes them? Their movements, their preferences, their relationships, when that data is held by a corporation that has done nothing more than observe their behavior? Can a contract be formed by clicking a button on a screen? What does it mean to have consented to terms and conditions that no human being has ever actually read? Slowly, haltingly, case by case, the law began to find its way into the digital world. Of all the legal challenges the digital age has produced, none has proven more complex or more consequential than the question of privacy. The United States moved further. A famous 1890 Law Review article by Samuel Warren and Louis Brandeis, later to become a Supreme Court justice, argued for the recognition of a right to be let alone as a legal principle. American courts and legislatures gradually developed privacy protections, though they remained fragmented, inconsistent, and frequently outpaced by technology. Then came the internet, and then came the platforms. The European response was the General Data Protection Regulation, the GDPR, adopted in 2016 and enforceable from 2018. A comprehensive legislative framework establishing individual rights over personal data. The right to access it, the right to correct it, the right in certain circumstances to have it deleted, the so-called right to be forgotten. The common law jurisdictions responded more unevenly. The United States, with its stronger tradition of protecting commercial speech and its more skeptical attitude toward regulatory intervention in private markets, produced a patchwork of state-level privacy laws rather than a unified federal framework. The debate is ongoing. The law is still catching up. But what is not in doubt is that the questions being asked about the limits of corporate power over individual information, about the duties owed by platforms to the people who use them, about the right of individuals to control the data that defines them in the digital world, are recognizably legal questions in the oldest tradition. Who has power over whom? What are the limits of that power? What remedy does the law provide when those limits are exceeded? The questions have always been the same, only the facts change. It would be comfortable to end this part of the story with a note of simple progress, of a tradition steadily improving, steadily expanding, steadily delivering justice more widely and more reliably across the centuries. But the common law tradition has never been quite that tidy, and honesty requires something more complicated. Access to law has never been equal. It has always favored those with resources, the ability to hire skilled lawyers, to sustain the cost and time of litigation, to navigate systems designed by and largely for the educated and the propertied. Legal aid, state-funded assistance for those who cannot afford legal representation, has existed in various forms in common law jurisdictions since the mid-20th century. But it has been cut, restricted, and eroded in many of those jurisdictions in recent decades, leaving large portions of the population effectively without meaningful access to the legal system. The law has not always served justice. It has been used to enforce slavery, to deny women basic rights, to exclude and oppress on the basis of race, religion, and a dozen other categories. These were not aberrations from the common law tradition. In many cases, they were the common law tradition at particular moments in its history. The same courts that protected the rights of propertied Englishmen presided without evident discomfort over systems of colonial subjugation that denied those same rights to millions of people beyond the seas. The tradition carries that history with it. It cannot be edited out. And yet, and this is the tension that defines the common law at its most honest, the tradition has also, over time, and with enormous effort, been turned against those very injustices. The same legal reasoning that once enforced segregation was deployed in different hands and different times to strike it down. The same framework of rights and precedent that once excluded women from public life was invoked by those same women and their allies to demand their inclusion. The common law is not a guarantee of justice. It is an arena in which the argument about justice, about power and rights and accountability, is made, contested, and slowly, imperfectly worked out. That has always been its nature, and it remains its nature still. The argument continues, as it always has, as perhaps it always must. Let it carry you gently into the quiet dark. For most of its history, the common law has been a human institution in the most fundamental sense. Its judges were human, its lawyers were human, the reasoning it demanded, the weighing of competing principles, the application of precedent to new fact, the exercise of judgment in the face of ambiguity, was at its core a distinctly human activity, shaped by human experience, human values, human fallibility. That assumption is now, for the first time in 8 centuries, being seriously questioned. Artificial intelligence, the development of computational systems capable of processing language, identifying patterns, and generating outputs that resemble human reasoning, has arrived in the legal world. And it has arrived not as a distant theoretical possibility, but as a present, practical reality. AI systems are already being used to conduct legal research, scanning millions of cases in seconds, identifying relevant precedents, summarizing arguments, drafting initial versions of legal documents. Tasks that would have occupied a junior lawyer for days can now be completed in minutes. The implications for access to justice are potentially significant. If AI can reduce the cost of legal research and document preparation, some of the economic barriers that have long kept the law out of reach for ordinary people might begin to fall. Because the common law does not just produce outcomes, it produces reasoning. It requires judges to explain in published opinions why they decided as they did. That reasoning, the ratio decidendi, the principle on which the decision rests, is what becomes precedent. It is what future courts will read, interpret, apply, and distinguish. If AI systems begin to assist in that reasoning process, and some already do in limited ways, questions arise that the tradition has no ready answer for. Whose reasoning is it? If a judge uses an AI system to identify the relevant precedents and structure the legal argument, and then adopts that structure in their opinion, is the reasoning the judges, the systems, some collaboration between the two? And if the system's training data contains the biases of the legal past, the centuries of exclusion, of racially discriminatory precedent, of law shaped by the interests of the powerful, does the AI reproduce and entrench those biases, or does it, at sufficient scale and with sufficient care, begin to average them out? These are not hypothetical questions. They are being asked right now in law schools and court committees and judicial conferences across every common law jurisdiction. The law that began with the king's judges riding muddy roads to hear disputes under oak trees is now contemplating whether a machine might help decide what justice requires.